Case number 112269, State of Kansas v. Kyle Carter.
May it please the Court, Samuel Shire of the Kansas Appellate Defender Office appearing on behalf of the defendant appellant, Kyle Carter. Your Honor, may I please reserve 3 minutes of rebuttal argument?
3 minutes is granted.
Thank you, Your Honor. Unless this Court would desire otherwise, I'm intending to focus argument today primarily on the prosecutorial misconduct issues raised in the briefs and address the other issues as time permits. With regard to the closing argument errors...
Excuse me, counsel, for the benefit of people who are watching us on their computers, would you mind giving those folks about a 60-second factual overview as to what brings us here today?
Yes, Your Honor, absolutely.
Thank you.
My client, Kyle Carter, was with his friend, Trenton Custer, at a friend of theirs' residence late at night, about 3:30. At some point, the individuals at Ms. Wilmore's house noticed that Ms. Wilmore's car was being burglarized. Trenton Custer and Kyle Carter both chased after the man who was burglarizing the vehicle. It's indisputed that the person who was burglarizing the vehicle ended up being stabbed 3 times and that he died of his stabbing wounds. The state's theory of prosecution was that my client, Kyle Carter, either had stabbed the victim in this case or had aided and abetted Trenton Custer in stabbing the victim. Mr. Carter's theory of defense was that he did not stab the victim and did not aid and abet in the stabbing of the victim.
And he was convicted of what charges?
Premeditated first-degree murder, Your Honor.
All right. Thank you, counsel.
I'd like to start out with the premeditation arguments that the state made in closing. The state argued, quote, "The requirement is the state of mind. The defendant has to think about the act of killing Carl Cooper before he does it. He has to consider that this is what he is going to do. It just cannot be instantaneous. He had more than 2 blocks to think about it. We will get into that, but that is what premeditation means. That is the definition of premeditation. That is what the state is required to prove." We believe that this is an inaccurate statement of the law. All instantaneous killings are not premeditated killings, but it is not the case that if there is more than instantaneous intentional action, a homicide is necessarily premeditated. I think this court's case law pretty clearly articulates that premeditation refers to a defendant's reflective state of mind. It really doesn't have to do with how long a defendant has acted intentionally. And I believe the Jones case that we cited in our brief is very exemplative of this principle. In Jones, there was uncontroverted evidence that a victim had been strangled, and that strangulation would have taken at least 2 to 3 minutes, I believe. And this court held that the district court was still required under those circumstances to instruct the jury on second-degree murder. And that was because it is possible for a defendant to act intentionally but without premeditation for a prolonged period of time. So when the state is arguing that the only thing it has to prove is that a killing was not instantaneous, that was incorrect. And when the state is arguing that the distance, the amount of time it takes to run 2 blocks, I believe the trial evidence was that the chase would have been approximately 850 feet. The time it takes to run 850 feet is not, by definition, the amount of time necessary to form premeditation. So those arguments were very misleading to the jury. We also believe that the state erred when it instructed the jury that it could consider Mr. Carter's lack of remorse as evidence of premeditation. And I don't believe that this court has ever clearly indicated whether a lack of remorse can be circumstantial evidence of premeditation. But we would argue to this court that as a matter of logic, It cannot be. Remorse is an after-the-fact emotion. It really has nothing to do with what a defendant thought about, what his thought processes were prior to the act of killing. And we think all it really does is inflame the passions of a jury. Essentially, it's asking them to look at the moral failing of a victim, of a defendant, his lack of remorse, rather than focusing on evidence that would prove the elements of a charged crime. And so for that reason, we think the lack of remorse arguments were also erroneous.
You don't think logically that someone who thinks about an act, determines that they're going to do the act, would be more comfortable afterwards having done exactly what they thought about doing versus someone that did it without that level of contemplation? In other words, if you did exactly what you thought and decided you were going to do, it would be less likely that you would second guess yourself or be remorseful, don't you think, as a matter of logic?
I don't believe that that's the case, Your Honor. Now, if somebody is acting calm, cool, and collected after a killing, I think that might give rise to an inference that the killing wasn't accidental and that it was expected. But to say that somebody doesn't have remorse and that's evidence of premeditation, I just don't see what the connection is. If you kill someone instantaneously, that doesn't necessarily mean that you are going to have remorse. I just don't know what the connection is.
What would it be relevant to, if anything?
Well, I think it would not be relevant in a premeditated murder trial at all, Your Honor, the lack of remorse. I don't believe that it would be.
So when, if ever, is it relevant in a criminal case?
The only thing I could imagine, Your Honor, would be in a sentencing proceeding. I don't think it would ever have any bearing on an adjudication of whether somebody was guilty or innocent of a charged crime.
Let me go at it a different way. Do you think it's more or less likely that a cold-blooded killer would be remorseful as compared to someone who you couldn't put in that category?
Well, Your Honor, I think I don't know the answer to that, and I think that's the problem, is that it involves speculation.
Well, that's part of what circumstantial evidence is, and it's not speculation, it's inference. Is it reasonable to infer that the lack of remorse indicates an intentional, premeditated act? That's what we're looking at. And
Yeah.
You're saying that's not a reasonable inference?
I don't believe that it is. I mean, I think a jury can look at the conduct of a defendant after the fact, and if he's calm, cool, and collected, that would tend to indicate that it wasn't an accidental. But as far as what somebody's emotion is, do they regret what they do? We think that's just inflammatory information to put in front of a jury. The most serious incident of prosecutorial error that we believe occurred during closing argument happened at the very beginning of the state's rebuttal argument. The state argued to the jury, quote, "So I think at this point, ladies and gentlemen, you understand how this works. We try them separately. Kyle Carter says it was Trenton Custer. Trenton Custer says it was Kyle Carter. And guess what? That's exactly why the law of aiding and abetting exists." As I read the state's brief, it's not making any argument that there was any trial evidence which would remotely suggest that Trenton Custer has ever accused my client, Kyle Carter, of stabbing Mr. Cooper. So regardless of what the state's motivation was when it made the argument, it is clearly telling the jury that at some point in time, Trenton Custer had said that Kyle Carter was the individual who stabbed the victim in this case. So by referring to this evidence, or this non-evidence, the state seriously prejudiced my client's trial. So I think there's a reason why the state routinely offers plea deals to criminal defendants to secure their testimony at the trial of a co-defendant. And that's because it is very useful testimony and evidence to secure convictions in cases that go to trial. And that's exactly what the state was able to do in this case by referring to facts not in evidence. When the state is saying that the co-defendant in this case said that my client was the person who committed the stabbing, it is getting in basically co-defendant testimony, which did not exist and probably, at least from what we can discern from preliminary hearing testimony, was not even accurate, aside from the fact that it was not reflected by trial evidence. So that, we believe, is also a seriously prejudicial error.
Can I have you address one other point beyond prosecutorial misconduct? To see your time's winding down.
Yes, Your Honor.
And that has to do with the lesser included instructions, specifically the reckless second-degree murder. I think the state's taken the position a skip rule can apply there, or what we don't no longer call a rule, we call a matter of logic. I'd like to hear your response to that.
Yes, Your Honor. So in Longoria, I believe this court applied the skip rule when it was doing a harmless error inquiry. And we don't believe that that would be appropriate in this case because when you're skipping the jury instructions, you know that the jury was never asked to decide based on the counts that were submitted to them, or the offenses that were submitted to them, whether or not this was an intentional killing or not. The jury was not given the option of deciding if this was an unintentional killing.
Unintentional, yeah. They did get intentional, didn't they?
Yeah, they got a second-degree intentional.
Okay.
So they got premeditated, intentional, and we believe that reckless second-degree murder should have been given, and that the skip rule cannot be applied in this court's harmless error analysis.
So if I'm understanding you, your position or your argument is that they're different in kind, that they don't nest, that unintentional doesn't nest within intentional, right? I mean, is that basically it? That if the jury got to intentional, thought about intentional, that wouldn't necessarily imply, as a matter of logic, that they disregarded the next, or if they got to pre-med, that you don't get eventually to unintentional at all. That's why the skip rule doesn't apply?
Yes,
that's kind of that they don't nest within one another?
Yes, that's basically the argument, Your
Different
Honor.
in kind. Okay, thank you.
So should the jury be instructed that they consider that instruction separately from typically how homicides are instructed on, and you go from the highest to the lowest, and if you don't reach a decision on the highest, you go to the next, or how would you instruct in this instance?
Well, Your Honor, I think the case law is that the jury has to progressively go down.
Right. So if they agree that it's a premeditated murder, why would they ever get to a reckless?
Well, Your Honor, I think the problem is that's the case whenever you're talking about an uninstructed upon jury instruction. Aside from the skip rule, if that logic is being employed, if the court had not instructed on intentional second-degree murder, and the jury had convicted on premeditated murder, it would be basically the same logic, that because the jury convicted on premeditated, they wouldn't have convicted on non-premeditated. So the skip rule really doesn't change that dynamic, I don't believe.
Was the jury given the PIC instruction that says if you have doubts about which of two offenses apply, you can only convict of the lesser?
I would presume, Your Honor, but I would have to check the record to make sure that was the case.
That's always seemed to me to be a little contradictory to the progression argument. If you decide it's not this, then you go to this, but then you have an instruction that tells them that if they're looking at two different instructions and have a question, they have to go with the lesser, because following the argument that progression takes it out of the skip rule applies because of progression, then you're never comparing two. You're
Yeah.
always just looking at one.
I think that's absolutely right, Your Honor.
Let me ask you about another instruction. You complain about the reasonable doubt, but that the obligation language, but wasn't that during voir dire?
Correct, Your Honor.
And when the jury was given their instructions before deliberation, they were given the correct instruction?
They were given the "you should convict" language, I believe.
Okay. So you're not complaining about the instruction that was in the packet that was read to the jury right before deliberation. You're only complaining about what the judge said to the whole panel.
That's right, Your Honor. I see I've gone over my time limit. Unless this court has any further questions, I would reserve the remainder of my argument for rebuttal.
Any more questions of counsel? Thank you, counsel.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I will also focus my comments on the misconduct claims that counsel has addressed today and submit the remaining issues on the brief unless this court has questions.
Mr. Maloney,
Sure.
good morning.
Good morning.
I'd like you to think about, I think, a distinction that has been urged upon us in many cases over the years by prosecutors between error that the prosecutor injects into a trial by things said during closing argument, for example, and actual misconduct that might expose that prosecutor, for example, to a disciplinary investigation. And I'd like you to look at the misconduct that's been alleged in this case on appeal and tell me how you would categorize those points.
Thank you, and that's an excellent question, and it's one that we, as the state, always seek to draw that distinction. I think that so often, every time there's an argument made that a prosecutor did anything wrong, it's couched in misconduct terms by the defense. We certainly disagree with that and recognize and would argue that, like any human being, prosecutors are not perfect, and occasionally they do simply misspeak or say something in error that is by no means an indication of misconduct, but simply that, an error, just like the court can err, just like I can and probably will err at times during this argument. And I would always urge the court to draw that distinction and look at carefully what the prosecutor is accused of. And certainly in situations where the prosecutor might simply misspeak at one point during a closing argument, but then come back and in other parts of his closing argument properly state the law, I would argue that those cases especially are apt to be described as, if anything, error rather than misconduct. And in this particular case, our position is that none of the comments by the prosecutor were certainly not misconduct, and we would urge the court to say that they were not even error. And I want to emphasize a point that I made in my brief, which is that I think sometimes when a defendant raises enough claims of error or misconduct, there sometimes is a tendency, I'm afraid, to think that, well, if they've raised so many of these claims, then surely there must be something there. And to think that, well, this comment was not as bad as this, and so therefore the one that is the most problematic, it therefore must be error. And I would argue that that is not necessarily the case, and I don't think it applies in this particular context.
So if I understand you, you suggested that the way we discern whether something is error at all, not even at the misconduct level, but error at all, is whether it was self-corrected. Is that the only criteria?
Not the only. It's certainly one. It's not the only. I think also clearly the extent to which, if the court were to find that the prosecutor has said anything inappropriate, I think clearly the severity of what he or she has said is something that should be taken into account also.
What about the vintage and clarity of the rule that's being violated. Shouldn't that also be a factor?
Certainly, the clarity of the rule, the extent to which the rule has been set forth in numerous cases, how long that rule has existed. Certainly also, I think it's not always entirely easy when you're just reading a cold record, but I think sometimes it can be done, that you can, from reading the transcript, I think you can also glean a little bit as far as the maybe the tone in which something was said, or you can understand something, and maybe you can discern that it was simply a misphrasing or something like that. So I don't know that there's any way to articulate an exhaustive list of what the factors can be. I think that it'll be something that would vary in every case.
Even if it's non-exhaustive, I'm just trying to get a fix on at least a few of the factors that might apply here. So certainly another one might be that the trial judge has made a ruling, and that ruling in that particular case, that's different from the rule that comes from many cases that's longstanding that everybody should know. Just in that particular case,
Sure.
that would be an indicator.
That would be one, and I think another that comes to mind right off the top of my head would be whether it's repeated. If the prosecutor one time during a closing argument says something that is questionable, but otherwise doesn't return to that comment, I think that would be an indication that it's not misconduct. I think that whether it's something that he harps on for a long period of time, even if he just makes the comment once, if it's then something that becomes a major focus of the closing argument. So yeah, those would be a few that come to mind. And I
Were
think
there-
Excuse me.
I didn't, you're on a line of inquiry here, I'll let you finish.
Okay. Well, with those factors, at least those factors in mind, I'd like to talk about a couple of the items that
Sure.
have been listed here by your opposing counsel. And the first one really is the first, and that is this encouragement to disregard and admonition. Would you say that would, if in fact we say that happened, assume that for the moment, and I understand you argue that point, but if we were to assume that was a rule that was violated, or something that should not have been said, would that fall on the error side of the line or the misconduct?
and we're talking now about when the golden rule type argument.
You know what happened. The you know what happened argument.
Oh, you know what happened argument.
I think the allegation or the assertion by your opponent is that was urging the jury to violate the admonition not to prejudge the case until they got to deliberation.
Well, I think that
Or you're saying it's neither,
sure.
but should we assume from your position that it's neither, is that it could only be error at the worst, not?
Correct.
Okay.
Yes.
I think
Yes.
that's all of you.
And I think especially given the fact that when you look at those comments that the prosecutor made, to me it seems fairly clear that his comments were based on and directly tied to the evidence. Perhaps it would be more likely to be found to be misconduct if the prosecutor was just saying, and then throwing out a bunch of things that were not tied to the facts or to evidence that had been admitted. But here, when he made those comments, he was directly referring to things such as the testimony, the evidence regarding the depth of the wounds, the number of the wounds, the lack of defensive wounds, all things that he was arguing were...
Let's talk about a harder one. Let's talk about the statement that Custer was accusing him of being the person who did the stabbing. That wasn't in evidence.
Not from my reading of the record, and honestly, in talking with the prosecutor at the time I was writing the brief, I believe this was one of those situations where, first of all, I think the comment itself was possibly not worded as clearly as it should have been. I don't think that he meant to imply that Custer had, in fact, already accused the defendant of doing that. I think it was more of just a general comment on aiding and abetting in general.
That was certainly the context. He was trying to explain aiding and abetting.
And I think that perhaps it was something where the prosecutor sometimes might know more information in his mind than what has actually been introduced into evidence at trial.
That's certainly a responsibility of the prosecutor not to pollute a proceeding with knowledge that they are in sole possession of, correct?
It certainly is.
It would be hard. I always think of that about the president. The president knows a lot more about stuff than we do, right?
Exactly. And I'm sure Mr. Phelps will be happy to be compared to the president to that extent. But I understand and agree that is something something that obviously you have to be careful to try to avoid. I think that, again, the phrasing, the way that he said it was such that any reasonable juror listening to it would simply understand that he was just offering a general explanation. And it was in response, I think, to what defense counsel had argued, which was to point out the fact that, hey, the state doesn't know specifically who inflicted the fatal stab wounds, and therefore they're just trying to play my client off against Custer. And so the prosecutor really was just kind of trying to explain, look, we know, jurors, you generally know how this works in a case like this. We don't need to be able to show who inflicted the fatal stab wounds because this is being tried under an aid and abet theory, and therefore the fact that two co-defendants might be pointing the finger at one another is not a big problem because we don't have to prove which one of them inflicted the lethal wounds.
I have one more I want you to address, and then I'll be quiet and let you have your turn. Is that okay?
Certainly.
Okay, one more, and it has to do. I have it down as basically the sixth allegation of error from your counsel on the other side, and it has to do with the statement during argument by defense counsel. That's where it started. That telling the juror to be the type of juror they would want in their case. There was an objection by the prosecutor. That objection was overruled by the judge. And then on rebuttal argument, the prosecutor talked about, it's funny the defense said that, and that colloquy there, or that piece of argument. What was going on there? Because to me, there's a fairly persuasive argument there that was a violation of the court's ruling, which may have been erroneous, but the court had ruled.
The court had ruled. I think the court simply overruled the objection and then just reminded the jurors that statements made in closing.
What exactly was said in the objection? Again, was it just objection, or was it?
I think the prosecutor objected that the remark was inappropriate because defense counsel was placing the jurors in the defendant's position.
Okay, thank you.
And my recollection of the transcript was that in ruling on it, the court didn't offer any expansive reason for why it was overruling it, or certainly didn't affirmatively say that what counsel had just stated was somehow appropriate. It was just to say overruled statements are not considered evidence. And honestly, I think that this is something that I see quite a bit during closing argument, is that when the prosecution does object to something that a defense attorney has said, oftentimes this is the response by the court. It seems like they will simply allow what has been stated to stand under the theory that, well, it's not evidence, so it almost seems like the court just kind of thinks anything goes. And I think that creates a dangerous situation. And in this particular situation, I would argue that there's no question in my mind that what defense counsel said was completely inappropriate. He was specifically, he wasn't even implying or trying to get the jury to get there somehow on their own. He just flat out said, you need to think about what type of juror you would want to have if you were in the defendant's position.
But Counselor, way back in State versus Manning, we said that the open door doctrine does not apply to prosecutorial misconduct. If what defense said was completely inappropriate, that's another matter. But that doesn't open the door for the prosecutor to be inappropriate.
And I don't think the prosecutor was inappropriate at all. I guess I have a hard time understanding how it could ever be considered inappropriate for the prosecutor to make a statement that is 100% accurate and properly reflects the law. And that's all that he did here, was to remind the jurors specifically, your job is to decide this case based on the evidence and the law, not on something like emotion.
Counselor, that's not how it came up. That's not how it came up. Prosecutor objected to defense counsel's argument, quote, completely inappropriate comment, object, end quote. That was overruled. And then eventually the prosecutor made further argument that places the jurors in the position of the defendant. The judge says, what the attorney say in closing arguments is not evidence, okay? And then it went on, and the prosecutor gets up there and said it's completely inappropriate.
He says that
arguing
after
he says
after a several sentence exchange in which he specifically says that's inappropriate for you to consider. It's not basically what he's arguing there in that passage is that it's not inappropriate for you to place yourself in anybody's shoes. That's not what your role is here. I don't know how the prosecutor, how else he can respond to something like that. I fully understand and I agree with the fact that the prosecution should be held to a higher standard. But I also think that the prosecution should not be required to not respond accurately to comments that are completely inappropriate by defense counsel there. It's one thing to say that the prosecution is held to a higher standard. It's another thing to say that in this case, the defense attorney can make a bold-faced golden rule argument, and that not only can the prosecutor not make that type of argument himself, but he can't even refer to the jury to the fact that, you know what, you really shouldn't be considering that, just like you shouldn't consider it on my behalf. You shouldn't consider yourself in the victim's shoes. It's just, I don't know what else he did the right thing. He objected when the comment was made. The court, for whatever reason, did not sustain the objection and just kind of punted on the matter by saying whatever happens in closing is not evidence. So as I argued in the brief, there definitely was one attorney in that courtroom who made an inappropriate golden rule argument. It was the defense attorney.
But my point is the prosecutor entitled to argue in front of the jury that the trial court's rulings were incorrect?
Well, I don't think you need to decide that, because I don't think that he argued that the ruling was incorrect. He was arguing that what the defense attorney did was incorrect. Now, obviously, by extension, if you want to use I guess we can use a syllogism or a logic argument and say, well, if the court tacitly approved of what defense counsel did, then the prosecutor must indirectly also think that what the court did was incorrect. But I think that when you look at his comment there, he specifically says that it's funny that the defense would ask you if you're this type of juror, and then he goes on to say that that's inappropriate. So his comment was clearly focused on defense counsel's actions, not on the ruling that the court made. And that's how I distinguish the case from the case law that the defense cites, where it was an issue where the prosecutor was informing the jurors to just disregard a lesser included instruction that the court had decided to give. In that case, very clearly what the prosecutor is telling the jurors to ignore is something that the court has done. Here, it's a response to something that the defense attorney has done. And again, while I think it's perfectly appropriate for prosecutors to be held to a very high standard, I think that in situations like this, there has to be some recognition that the reality of this situation is that the defense attorney had made an inappropriate comment, and the prosecutor simply pointed that out. And I think that what the prosecutor's argument, the substance of it, was no different than what the jury instructions always tell every juror, which is your job is to decide this case based on the evidence and not based on emotions, not based on sympathies, not based on this golden rule concept. And that's, I would argue, that's all the prosecutor did. And I think this would be a perfect example of something that would also be a factor in deciding whether something would be misconduct or error, if anything. I would say that here, where the prosecutor clearly took the appropriate step to object, and then that objection was not sustained, that he dealt with it the best way that he possibly could. So to the extent that it was not perfect, it would simply be error, if anything, and certainly not misconduct.
Counsel, let's address that distinction that you just made, and it follows the distinction that Justice Breyer made, I think, about 15 minutes ago when you first stood up, and that is the difference between prosecutorial misconduct and prosecutorial error. And there was discussion that prosecutors don't like to be told in appellate opinions that they have committed misconduct, and that may be because, as Justice Breyer was suggesting, that could lead them to some ethical issues and perhaps being turned into the disciplinary administrator. Short of that, prosecutors not being told they have misbehaved, i.e. misconduct, why are we arguing whether something is error or misconduct? Does it make a difference in the ultimate determination of, let's say, the harmlessness inquiry?
I would argue that it probably would. I think that to the extent, at the very least, I think that that would be relevant when you get to the second part of the analysis, which is whether it is gross and flagrant and or ill will and would deny the defendant a fair trial. Certainly, when I think probably when any layperson hears the phrase misconduct, the word misconduct, it conjures up images of somebody intentionally doing something, intentionally engaging in misconduct, knowing that what you're doing is wrong, as opposed to, in this context, error being something that might have just inadvertently been said in the heat of the moment. One of the expressions that my colleague Mr. Isherwood likes to use is at the speed of trial, where things are happening quickly and you don't always have time, like I do, before an oral argument to prepare as extensively. Things come up in trial.
So the prosecutor doesn't know that there will be a closing argument?
Well, the prosecutor
beforehand. I mean, I don't know about prosecutors, but I always prepared at least an outline of my closing argument and a theme of how I was going to defend. And a lot of times in the cases that we throw a flag on, it's because the theme of the prosecutor's argument's improper. But the point is, I'm having a little trouble talking about the speed of trial on a speech that's given to the jury that you've been given time to prepare.
And what the distinction I would draw there is, I think oftentimes, and not all the time, and certainly in this case it's kind of a mixed bag, but many of the times the misconduct allegations stem from comments that are made in rebuttal closing. And so that, in that context, the argument that the prosecutor has had ample time to prepare an outline, I think, loses some weight when you have no idea, obviously, what the defense attorney is going to say.
So should that factor into our analysis?
I think that's another factor. If it's something that the prosecutor, such as the comment about the golden rule argument, that's something that obviously the prosecutor had very little time to craft a response to. So I think, yes, it does play at the very least into the second prong, which is whether it is prejudicial error misconduct or error requiring reversal. And I think just the other reason, which it might not affect the ultimate decision of an appellate court, but I think, just speaking on behalf of my colleagues, I think it also, I would imagine any person that considers him or herself a professional does not want to be labeled as having committed misconduct simply because he or she misspoke. And I think it would be very useful to draw that distinction in cases and say, all right, we all agree that what happened here maybe was not appropriate, that the prosecutor should have either not said it or should have said it differently, but the record indicates that there's no reason to believe that this was done intentionally. It was not misconduct. It was a slip of the tongue that we're all guilty of doing from time to time. And so I think that it does, in certain circumstances, it can definitely affect the outcome of an appellate decision. And in other situations, even when it doesn't, I still would urge this court on behalf of prosecutors to start drawing that distinction, because it does, obviously, even if it doesn't lead to disciplinary proceedings, it certainly is something that to some extent hangs over a prosecutor when you've been labeled to have committed misconduct, even if that doesn't result in reversal.
Is it possible then to commit some misconduct that is so egregious that regardless of the weight of the evidence supporting guilt of the defendant, that a court should say, we are not going to allow this, reverse the conviction, remand for new trial, hopefully without the, quote, misconduct, unquote?
I don't think I would be conceding too much if I were to say that, sure, I think there could be certain situations. If a prosecutor got up in closing argument and said, this defendant's a liar, everything he just told you on the stand is a lie, and that in and of itself is enough for you guys to convict, and that's really all I have to. You can see situations that hopefully would never actually occur. But I think that, yes, if a prosecutor were to stand up in closing argument and make a just blatantly inappropriate argument that has been repeatedly, as Justice Breyer suggested, something that has been a long-standing rule that any responsible prosecutor knows, then yes, in that type of situation, it would certainly weigh towards finding that that is misconduct and that it's so over the line that perhaps reversal is necessary. But I think that these cases that we see far more often, that I've worked on for many years, are situations like this, where you have comments that are at worst borderline and can be, by a defendant with hindsight and with limitless time to look at the record, can be characterized by the defense as misconduct. And that's why we always argue in our briefs that another factor to consider is, does the defense object? Now, that doesn't mean that if they don't object that a comment all of a sudden becomes appropriate if it wasn't otherwise. But I think in a case like this, where you've got so many instances of alleged misconduct raised on appeal, and you see that a defense attorney was sitting in the courtroom throughout that entire episode and lodged but a single objection, that to me would also be a factor to consider, that those that were in the courtroom seeing this live, viewing the context, viewing the body language, did not see this as a problem, with one exception. And I think that certainly plays into the equation.
There's a couple factors there that occur to me, and one is, the incentives are wrong on the defense. I mean, at this point, if they've been told, if all defense lawyers know you don't have to object during, and you're still going to get your appellate issue, so that, the incentives are set up wrong for defense counsel to pop up. But the other thing we've said is that the court has a responsibility to step in. We've said district courts need to be vigilant and step in, and so it seems to me that perhaps is a better argument for you, because the incentives are there for the court to have a clean trial and not end up with a reversal.
Absolutely, yes.
The incentives are wrong for the defense counsel. The way it's set up now.
I understand, and I think that's something that I hope I did in this case. That's another thing when I mentioned, and as far as the lack of objection, is that it's not only the defense attorney who, as you said, obviously has conflicting motivations and sometimes is in a quandary in deciding whether to draw attention to something or just let it slide. But clearly the trial judge does not have that type of dilemma on his or her hands. And so the fact that as the one neutral arbiter in the courtroom, that the judge doesn't find anything inappropriate. And I think we should trust our district court judges that if something truly inflammatory or intentional were to have occurred, that I would like to think that the judge would, if warranted, step in there. And so that would also be something for this court to consider. I know I'm well past my time.
I just have just one quick question.
Sure.
on the jury instruction, and it might be surprising that it comes from me given my dissents in a lot of these cases, but what's your best argument that a reckless second-degree murder instruction should not have been given factually? It just seems to me that you have the scenario happening, there's a chase, there's 3 stab wounds, 2 to the leg and 1 to another portion of the body that might not be considered fatal when done. Why wouldn't this suffice for a reckless second degree?
Well, I think my best response to that would be based on the case law I cited in the brief, specifically Calderon, where I think it was a very similar type of situation where basically you've got a defendant who has made a self-serving statement that, or tried to suggest that this was not intentional, but there's so much evidence showing otherwise, and specifically the extent...
The intent to kill. I mean, maybe the stabbing obviously was intentional, but it's the
depth of the wound, of the wounds plural, is what I would point to here. That these were not. I think if you're just trying to slash somebody to send a message and stab them and hurt them because they have broken into a vehicle, it's very unlikely, if not impossible, to think that you're going to jab the knife in so far multiple times that it goes, I think on one occasion 6 inches deep and on another time 4 inches, both of those wounds being longer and deeper than the length of the blade itself. And I think there was testimony from the coroner to that extent that it would have taken an extensive amount of force. And I just think that when you compare this case to Calderon, it would show that not only was the act of stabbing intentional, but that the intent was in fact to kill. It simply... like in Calderon, I don't think we're at a point, or that this court has ever indicated, that simply a defendant's statement in and of itself is enough. If that were the case, clearly somebody could make a self-serving statement and get an instruction even if they shoot somebody 10 times in the head from point-blank range. So I think there obviously has to be some evidence.
But that is some evidence, isn't it? I mean, we've said that even a defendant's self-serving statement is some evidence, whether it's incredible evidence, but it's some evidence. And what you're saying is that even if there's some evidence, the judge gets to rule as to which is the more appropriate charge.
Well, I think the test itself allows the judge to decide whether there's some evidence which would allow a jury to reasonably convict of the lesser. And so that reasonably convict language is what I would point to, is that, yes, that is what gives the judge the discretion to not have to give every possible lesser when there's no credible evidence, or when there's no evidence that would reasonably lead to a conviction, because otherwise I think...
How do you square that argument with our constitutional mandate that the right to a jury is inviolate? And if there's evidence that would support two different crimes, even if a person might say it's more reasonable that it would be the greater than the lesser, but the lesser would be upheld on appeal as being appropriate, why isn't that a jury question?
Well, I think if there's a situation where it's a question between two things that are both reasonable and one is just more reasonable than the other, then I think that's the type of case where probably a lesser...
In whose view is
well, the district court. I mean, the district court has to always have a gatekeeping rule on that.
Well, and my answer is why? Why do we invest the judge with the fact finding to determine which is the more reasonable? Between two factually supported charges, why do we let the judge choose instead of the jury?
Well, I think I don't know how to answer other than just pointing to the fact that I think the legislature and this court's precedent has always done so. I personally, I think that a perfectly appropriate response is simply common sense. I think otherwise, I guess a battery conviction would have, an assault conviction. I mean, you can go down the line and say that there's always, that anything would have been supported, that if it had been convicted of any crime, then...
And where's the harm? If the prosecutor has all the evidence to prove the principally charged crime, then you simply prove it, you argue it to get the jury to make that decision. And the systems worked, and the people got what they needed, the conviction of the crime that was proved by the state. And if you withhold lessers, then the defendant's been denied the right to have the jury decide which crime he or she committed.
I think the harm is that the more you allow just unfiltered instructions into evidence, into the jury room, the more you allow that in, the greater chance that you're going to inject confusion, or that you're going to actually almost affirmatively invite jury nullification. You might get jurors who know beyond any reasonable doubt that the evidence supports the fact that this is first-degree murder, but you might get that juror who just feels like, well, for whatever reason, I don't want to convict this guy of first-degree murder, and they gave us this other option on reckless second-degree murder, so let's go ahead. So yes, I mean...
But that's not jury nullification. If the evidence would support the
reasonably
lesser, if it would support the lesser and the state appealed saying that that was incorrect, or if there was an appeal as to whether that conviction could stand, then it would stand. It would withstand the sufficiency of the evidence challenge on appeal.
But I think those are two different standards. In a sufficiency challenge, you're looking at everything in the light most favorable to the state. In an instructions context, you're looking at either a clearly erroneous standard, or obviously it depends on whether the defense is objected or not. So I think that's an argument that I know the defense makes a lot of times, is to say, well, had the instruction been given and they had convicted of the lesser, then the state would sure be up here on appeal arguing, well, yes, there was sufficient evidence to support it. But I think that's apples to oranges. I don't think that that necessarily ends it and says, well, okay, if the state would have been able to support the conviction had it been challenged on appeal, then that necessarily means the district court should have just gone ahead and given the instruction. I think that the district court has to have a gatekeeping role, or else every one of these cases is going to come down to the point where there's just such a ludicrous number of instructions given that it confuses the jury. And I would argue that that in and of itself is a harm, whether in any particular case the jury goes for the lesser or not. It's a harm that would always potentially be there and would grow significantly each time you add a lesser instruction that isn't supported. And certainly I would argue as a fallback position in this case that the fact that they rejected intentional second degree would cut against any argument that they somehow would have convicted on reckless second degree.
That seems to be a little inconsistent to me. If you're arguing that a whole list of lessers are going to confuse the jury, but convicting of a higher can't be error because they're going to stop after they find the conviction. If you're doing in descending order of severity, then they're not even considering. If you're arguing that the skip rule applies because they take the highest one, and if they find it over the second one, then it couldn't be the third one because they're not even looking at it, then how can it be confusing if they don't even look at it, at the lessers? You understand what I'm asking you?
I do. I do. And I can see some tension between those two ideas, but I do think that the general concept being the fact that the verdict demonstrates that they found that this conduct was not only intentional but premeditated, and therefore it would logically be inconsistent. You obviously cannot premeditate a reckless act, so I think it would be logically inconsistent to say that a jury that found that this was premeditated would have been...
You can't premeditate a heat of passion killing if you have sufficient provocation and I declare out loud, I'm going to kill you. That would ordinarily be sufficient to find premeditation in our other cases, but...
My understanding of heat of passion has always been that it applies when there's a situation where the defendant has been found to have acted without time for reflection. So I think in a situation where they were to declare, I'm going to kill you, that would negate any argument that it was not something that was done in a premeditated manner. Perhaps it would be considered he obviously had enough cooling off period, or he had enough time to process and make a calculated decision.
Counsel, I think you've been up here over 30 minutes. Would you like 60 seconds to wrap up?
Thank you, Your Honor. I certainly don't plan to take the full 60, but I would just urge this court, as Your Honors have questioned today, I think that the general concept of prosecutorial misconduct as opposed to error is one that certainly deserves a discussion. And I would argue that in this case, there was no misconduct. I would also argue there was no prosecutorial error, but if this court finds that there were any misstatements by the prosecutor, that they were isolated, that they were cured by otherwise accurate comments by the prosecutor, and that certainly nothing occurred that would rise to the level of denying the defendant a fair trial. So for all of those reasons, we would respectfully request that the defendant's conviction be affirmed.
Thank you, counsel.
Thank you.
You reserve 3 minutes for rebuttal.
Thank you, Your Honor. I just want to touch briefly on the last argument that this court was discussing. And I'd like to hit the second part of the state's argument after it says that defense counsel's closing argument was inappropriate. It says, the fact of the matter is you are not sitting over there, and that is about as appropriate as me saying, are you the kind of juror that you would want to be if you were one of Carl Cooper's family members? And that, I think, we believe that seriously compounded the state's error Well, it's an entirely different error. It's telling the jury that it's not supposed to deliberate as if it were one of Carl Cooper's family members, that it would be completely inappropriate. And our position is, if it would be completely inappropriate to make that argument to the jury, it just should not be mentioned at all. The whole idea is you don't make this argument.
But it's not said in isolation, counsel. The very next thing that's said is, are you the kind of juror who is going to look at the evidence in this case and draw conclusions about what it shows you? I think what your opposing counsel has urged us to do is to start at, it's funny, and go all the way to the end of what I just read, to consider that he was frankly trying to make kind of a silk purse out of a sow's ear at that point. We had a situation where there was an appropriate objection. Defense counsel was urging the jury to put themselves in the place of the defendant, pretty straightforwardly doing so. That was not appropriate. Counsel objected. He got a less than clear ruling by the court, because even though overruled was spoken by the judge also basically told the jury to disregard it by saying statements of counsel are not evidence. It was kind of a hybrid ruling, really, when viewed critically. And so then he stood up and he said something wrong. It would be just as wrong for me to say this. You should be the jurors who consider the facts. Don't we have to look at that whole speech, not just one isolated passage?
Absolutely, Your Honor. And I think this court does have to look at the whole comment. And as I read the record, when I look at the entire record, I think what I take from this is that the prosecutor had an objection to defense counsel's statement and was upset that it was overruled, possibly even justifiably upset that the objection was overruled. And that in this argument, he is bringing another objectionable argument in front of the jury for it to consider. I see this as retaliatory. The prosecutor believed that defense counsel had gotten away with an improper argument, and so he was going to bring his own improper sentiment in front of the jury. And unless this court has any further questions, I would reserve the remainder of my argument at this time.
Any more questions? Thank you, counsel. We thank you both for your arguments this morning. Court will take this matter under advisement.